I think where we get into problems on just a disability is that we don't understand what the founders meant by the clause. If we think it means, we've decided that this is important for the national interest or for the common good or the public benefit, who are you to say you think we're wrong about that? And that's a judicially unenforceable test. But if the line is between, is it local interest or national interest, sure, at the margins it's going to be hard to figure that out, but in many cases, that's not just choosing not to defer to Congress's judgment about what's good or beneficial, but is putting a red light in the center of town, local or national. It's clearly local, and it seems to me that when we give an earmark to fund the red light in the center of town, not on a border state at the border, but in the middle of the state, that's an easily judicially enforceable test. And we can at least start there and knock out a whole lot of the stuff that's going under federal government. And then, and then fight over, when we get to the margins, the memorial on the World Trade Center memorial, maybe then the court says, this one's too close a call and we'll claim a non-justiciability there. I would be happy with that, because 90% of this stuff is going to be much more easy to define than that. I do want to add one thing. There was something Malcolm Feeley said that, and then winners write the history and Hamilton won. It's an extraordinary thing. Hamilton on this won for a brief period in the 90s. And then this becomes one of these central campaign pieces that the election of 1800 is fought over. And Madison and Jefferson win that election, and they prevail for another 60 years. And then you get this odd, and this is what most coherent Supreme Court decision ever. You get this odd decision in Butler where they said, well, we're siding with Hamilton, but then they strike down the federal spending bill because it didn't further an enumerated purpose. I'm sorry, that's not Hamilton, that's Madison. Right? I mean, they accept Madison's theory in the holding of the case, even though, so Madison may have won in name, but he lost at every step along the way. So I don't know how he ends up, Hamilton may have won in name, but he lost every step along the way. It's a very bizarre thing. And ever since, we viewed Butler as authorizing unfettered spending, forgetting that it struck down the spending at issue in the case.
Ilya.
It seems to me that the difficulty of line drawing should not lead to the conclusion that court should simply stay out of this area. If it did, the same can be said for numerous other parts of the Constitution that everybody agrees are judicially enforceable. Doctrines like equal protection, due process, reasonable search and seizure, all of those are just as vague or even more so than general welfare is, yet no one says that for that reason they shouldn't be judicially enforced. Moreover, I think the general welfare clause, if you read it in its full context, actually does provide you some constraints, is it doesn't simply say the federal government can spend for the general welfare, rather it says it can levy taxes to provide for the common defense and general welfare and pay the debts of the United States. So you know that at the very least, general welfare cannot be defined so broadly as to subsume providing for the common defense or paying the debts, because if it was read that broadly, then it would be completely superfluous and unnecessary to include these other two items. So the text provides you some guidance. And then finally, I agree sometimes judges will vote their partisan preferences here. They often do in other areas of law as well. But I think over time, as we develop a tradition and precedent in this area of taking the spending clause seriously, there can be a cross-ideological consensus, at least on some things, as there is in these other areas, equal protection, free speech, and others. In particular, yes, we can argue about difficult boundary problems, but I think certainly there was at least a broad consensus among many people that something like federal spending for the bridge to nowhere is not actually a meaningful national interest. And there are many other similar places, and we can at least begin to build on that and gradually apply the standards to more difficult cases, just as we've done in these other areas where the Constitution also has relatively broad language.
Well, Rick, save for the founders and perhaps former Chief Justice Rehnquist, there doesn't seem to be a constituency for federalism. I don't think the states really are constituents. They are some days, but not others. I can't think of an interest group that is inherently interested in it. They're interested in it on topic-by-topic basis. That kind of thing makes me think that judges should be the ones responsible for enforcing it, or does that still take you back to the same problem? The standards are too difficult.
Well, I'm for judicially enforced federalism. I just tend to think that the spending clause in most federal regimes takes care of itself. This is where I differ from Malcolm, by the way, and that's why I usually am fighting on panels against Malcolm. I think that, in general, for regulatory powers, judicial limits make sense. The thing about the spending power is that there are some inherent political process restraints that work pretty well. Congress is strapped for dough. Right now, Obama's facing enormous pressure to cut down on spending. He could not do a second round of stimulus. Everybody knows it. So the notion that Congress has unlimited spending power strikes me as illusory or mistaken. Congress's spending power is really quite limited. States also turn down grants all the time whenever the opportunity costs of the grants exceed the amount of the money. Mostly they turn down grants for low-income housing. So there are states that just won't apply for CDBG monies, Community Development Block Grants, because they don't have to basically allow a lot of low-income housing into their jurisdiction. I should say local governments. So it's not, if a Congress were to proffer a grant that didn't cost the opportunity cost of the condition, you can bet that local governments and state governments would turn it down. The reason why you don't see that happen very often is mostly Congress ponies up very generous amounts of money. And state and local governments are more than eager to grab at it. Now, I think that the bigger problem is one that Ilya identifies. There is no subnational jurisdiction constituency for federalism when Congress ponies up huge amounts of money. Generally, the subnational jurisdictions, of course, cave. They'd be fools not to. The main restriction there is not a constituency-based restriction. It's based upon the fact that the feds are cash-strapped. They cannot use their credit card indefinitely. We see that right now. They do not have unlimited taxing capacity. And as long as state and local taxes remain more popular than federal taxes, as they consistently have been shown to be, according to the old now defunct Advisory Commission on Intergovernmental Relations, property taxes, sales taxes, and state income taxes tend to be more popular than the federal income tax. And so I think, in general, that's the best safeguard against the feds using their pocketbook to destroy federalism. Their pocketbook has limits. Now, on the mushiness of the standard and whether courts can enforce it, it's not that the text of the General Welfare Clause is mushy. It's that the doctrines that are being proffered by scholars and judges to enforce that text are mushy. With the Equal Protection Clause, we immediately get a taxonomy of classifications that crystallize the doctrine, and so most of the time it doesn't apply. And when it does apply, we're pretty sure that we know it applies. Racial classifications get strict scrutiny, everything else gets nothing, right? Substantive due process. We inch out with a few foundational rights, but generally we don't enlarge that rights. And if somebody said, look, the balancing test for substantive due process, if liberty is really, really important, and judges will do this on a case-by-case basis, assessing the importance of the individual liberty, will strike down the law, that judge would immediately be sequestered. That kind of doctrine is not a manageable doctrine. And therefore, Griswold, Roe, and Eisenstadt v. Baird have largely been cabined, strictly limited, because of the failure of a free-floating substantive due process doctrine. So we have a tiny number of foundational rights. Quickly, the courts retreat from any free-floating substantive due process doctrine, and this crowd here, of all crowds, should be aware of the failure of amorphous doctrines like substantive due process and hardly be applauding the court into going into a new area with a substantive due process for the General Welfare Clause. Right? I can just see a latter-day Scalia denouncing a sort of case-by-case general welfare jurisprudence in exactly the same tones as Justice Scalia rightly denounces case-by-case free-floating assessments of liberty that we used to get out of Justice Brennan. And so for that reason, I think this is an area where courts can't venture into unless a judge were to come up with a very crystallized and limited doctrine, something like strict scrutiny for certain categories of spending. But the general notion of general welfare is not that doctrine. And that doctrine will never be adopted by the courts, nor should it.
I'll agree with the first half of that.
But you're asking a judge to come up with the doctrine and theory, and the judges are looking to the professors, and I've got 4 great professors. That seems quite unfair. You're attacking us for being partisan. You can't even come up with a line that we could accept and draw. Rick, I wanted to ask you your sense historically, the extent to which the federal government enforces these conditions, okay? So if you think of No Child Left Behind, they're getting all this money. Short term, there are not a lot of conditions or onerous conditions. They've got to take tests, progress, but there is, I don't know if it's 2014, there is a time by which they have to have made progress, and then there are some pretty severe enforcement mechanisms. What's your sense, assuming the law is still in place, it continues to be carried out by this administration, what's your sense of whether those conditions would be enforced? I mean, if you compare it to conditions, sometimes you accept federal money and a state has to expose itself to civil rights actions brought by individuals. Those get enforced, right? The individual just files a lawsuit, they can sue the state for money damages. There's no problem there. But here it's the Secretary of Education that would be enforcing this, and I would think that would be a very politically interesting question.
Yeah. Well, I have a strong opinion about this, but I don't want to filibuster.